Good evening. Thank you all for joining tonight's event. My name is Van Swearingen. I'm a partner at Rosenbein, Galvin, and Grunfeld, and along with Chris Hu, I'm the co-chair of the Gala Committee for the Bay Area Lawyer Chapter of the American Constitution Society. I'm thrilled to welcome you all to our 12th Annual ACS Bay Area Gala. Now, normally, our gala is held as an in-person event at the Sir Francis Drake Hotel with great food and ample time for attendees to socialize with friends, make new contacts, and mingle with the speakers. Unfortunately, due to the ongoing pandemic, we must hold the gala over Zoom for the second year in a row. We do look forward to seeing you in person next year, but for tonight, we have a terrific program packed into this 1-hour Zoom presentation. The theme of this year's gala is American Democracy Under Attack. In the wake of the Supreme Court's decision in Shelby County versus Holder, states across the country have made it harder for citizens, particularly people of color, students, the elderly, and people with disabilities, to exercise their fundamental right to vote. Since the 2020 election, that assault has intensified. State legislators have introduced hundreds more bills across the country that would restrict access at the polls and change the rules of democracy. Earlier this month, the Supreme Court issued its decision in Brnovich versus Democratic National Committee, holding that Arizona election policies that banned out-of-precinct voting and outlawed ballot harvesting did not have a racially discriminatory purpose and did not violate the Voting Rights Act. This ruling suggests that the High Court will not protect against other state laws designed to further erode Americans' right to vote. This evening's presentation on voting rights could not be more timely. Indeed, just 2 days ago, President Biden emphatically stated that we are facing the most significant test of our democracy since the Civil War. Amidst these troubled times, we are fortunate to have as guides a terrific panel of speakers. Russ Feingold, the senator from Wisconsin from 1993 to 2011, and the current ACS president, will provide opening remarks on the importance of ACS at the national level, as well as his perspectives on how campaign finance issues are related to the present voting rights crisis. United States Senator Alex Padilla will talk about voting rights in California and what's happening right now in Congress. Our keynote conversation will be led by two leading voting rights experts, Professor Franita Tolson and Allison Riggs, who will discuss the scope of the present threats, as well as the actions that activists, litigators, and elected officials are taking to safeguard access to the ballot box. To be sure, the views expressed by the speakers reflect their individual opinions and should not be attributed to ACS. ACS is a nonpartisan 501c3 organization and does not endorse any candidate or political party. Now, before we get started, just a few words about our local Bay Area ACS chapter. We engage judges, policymakers, activists, and academics on critical legal and policy issues. We partner with law student chapters, and we teach middle schoolers about the Constitution. We organize lectures, book talks, panels, and social networking events throughout the year on a wide variety of topics, including most recently, our annual Supreme Court Term in Review event, which many of you attended on Monday. Our events are usually free, open to the public, and offer CLE credit. We encourage you to become a member and to get involved. Now, without further ado, let's get the gala underway. Senator Russ Feingold.
Thanks a lot, Van. Welcome to everybody. I am Russ Feingold, and I'm honored to be the president of the American Constitution Society. And you can attribute anything I say to ACS, I guess, in my case. But thank you for attending the Bay Area ACS Lawyer Chapter's 12th Annual Gala. It's no surprise that our topic, our theme, our focus tonight is voting rights under attack. Your chapter has chosen an apt topic to discuss, with voting rights in nothing short of crisis mode, particularly following the recent Supreme Court decision in Brnovich versus DNC, which upheld, in my view, basically two very malicious voter suppression laws in Arizona. With that decision, and as Van said, the previous decision in Shelby County, the Supreme Court has basically gutted the Voting Rights Act, which was a necessary and historic piece of legislation for fulfilling our multiracial democracy. The assault on voting rights by certain states, specifically the voting rights of people of color, make clear that the Voting Rights Act is just as needed today as it was in 1965. And yet the VRA now exists almost only in name only. Both of the relevant Arizona state laws upheld in the Brnovich decision were passed ostensibly to combat voter fraud. But we know that that was a subterfuge. These laws should be called what they are, and that's voter suppression. The lower courts found that these laws were passed in part due to conservative lawmakers' self-interested motivation to eliminate efforts to ensure that minority voters' ballots were received and counted. The Supreme Court's decision to ignore that legislative history and instead to uphold these laws says just how far this court has moved to the right. The 6-3 majority has opened the door for even further voter suppression, with the impact being disproportionately felt by people and voters of color. Put simply, we now have a Supreme Court that is hostile to voting rights. This is deeply alarming in a country where racism is embedded in our laws and institutions. Yes, the president was right in what he said in Philadelphia. And in fact, I was serving with the man who is now our president in the United States Senate when there was no question that voting rights was a bipartisan, across the board issue. This is a terrible change. And it's one reason why this country needs to undertake a broader truth, racial healing, and transformation initiative. We need to tell the truth about how our laws entrench racial hierarchy. This includes the history of voter suppression laws from decades prior to the laws being enacted in several states today. It's too easy for people to see these Arizona laws, if you just look at them on their own, as being potentially reasonable. But if you look at the history and what they're intended to do and how it fits into the history of voter suppression, it is not possible to see them as reasonable. And that's why the entire picture has to be painted for the nation. ACS therefore recently announced at our national convention that we support a truth, racial healing, and transformation commission in the United States. And we're particularly focused on the need to reckon with how our laws and legal systems have and still do entrench racial inequity. In terms of next steps on voting rights, there is now even greater urgency to passing federal voting rights legislation. We need to establish national standards to protect voting, or we risk having our elections determined as much by who is not allowed to vote than by those who do vote. Federal legislation will almost certainly require reforming the filibuster. At a bare minimum, the filibuster should be restricted so it cannot obstruct legislation that is essential to our democracy, like voting rights. I recently had the pleasure of having Representative James Clyburn come on our new ACS podcast, Broken Law, as we call it, and he specifically has supported this idea of at least, at a minimum, making an exception for voting rights. The filibuster isn't written in the Constitution. It's just a parliamentary rule subject to change with a simple majority vote of the Senate. There is no moral or democratic equivalence between this Senate rule and the constitutional right to vote. The filibuster has been reformed several times prior, and it must be again. In fact, my favorite recent quote on this comes from the new wonderful senator from Georgia, Senator Warnock, who said the notion that you would protect the rights of the minority of the Senate while you deny the rights of the minorities around the country is an absurdity. In addition to legislation, we also need to talk seriously about court reform. Our Path to the Bench project is doing incredible work to supply the White House with diverse, qualified candidates for the federal bench, and we applaud the Biden-Harris administration's demonstrated prioritization of the courts. It's imperative that we build a federal judiciary that finally reflects the public it serves. That said, we need to do more than nominate exceptional judicial candidates. We have to address the naked theft of the Supreme Court. The 6-3 majority in Brnovich included the two justices who, in my view, occupy stolen seats. Who knows how that decision would have come out if Merrick Garland had been confirmed, and if the seat left vacant by Justice Ruth Bader Ginsburg had been filled by President Biden. The theft of our highest court discredits our judiciary, and is impacting cases that go to the heart of our democratic legitimacy. The right has been methodical in its attack on voting rights at the federal, state, and local level. We have to be equally methodical at protecting voting rights at the federal, state, and local levels. Remember, even if you fix the federal law, there's still the problem with reapportionment at the state level that can greatly distort things. The progressive legal community has never been as important as it is right now with our democracy in such peril. The Supreme Court has made it harder to vote and easier to buy elections. The conservative movement appears to be intent on preserving minority rule. We should expect these trends to continue unless there is a concerted effort to reverse them. So the onus is on us to do so. We need to pursue every opportunity available to protect voting and uphold the credibility of our elections. This means national legislation, state legislation, and court reform. It means an engaged citizenry and legal community, and not just in presidential election years. This is why I'm grateful to be part of ACS. Our network, our advocacy, our progressive leadership is needed now more than ever. So thank you to Gala co-chairs Christopher Hu and Van Swearingen, board member Christopher McLam, and co-chairs Maxwell Pritt and Mary Hannah Weir for their tireless work in organizing this wonderful event. Thank you to our sponsors for their generous support, our patrons, Leif Cabraser, Hyman, and Bernstein, LLP, Kecker, Van Nest, and Peters, LLP, our benefactors, Lauren Key, Rosen, Bean, Galvin, and Grunfeld, LLP, our donors, Deary Tangri, LLP, Fenwick and West, LLP, Horvitz and Levy, LLP, Zell, and our friends, the ACLU of Northern California, the Equal Justice Society, Folger Levin, LLP, and the Law Office of Dan Roth. I also want to thank you for your support of ACS and for attending this wonderful program. We hope that you'll continue to support our work by making a tax-deductible contribution today. To donate, text 258-163 to 1-855-575-7888. We look forward to seeing you at future events, connecting with you, our nationwide network of progressive lawyers, law students, advocates, and thought leaders, and working with you to transform our legal system so that it is grounded in equality and justice for all. My thanks in advance to Senator Alex Padilla for your leadership in protecting our democracy and, of course, for providing remarks at today's program. Thank you to our brilliant speakers for speaking to us on this important and timely topic, Allison Riggs and Franita Tolson. I have the honor of working with Franita through her role in the ACS board, and we at ACS are proud to have presented Allison with our Carliner Award at last year's convention for her important and tireless work. So I, like you, am eager to hear from them this evening. So I will now pass the mic back to Van.
Thank you, Russ. Our next speaker could not be present this evening, but has recorded a special presentation for the gala. Alex Padilla is the junior United States Senator from California and served as the 32nd Secretary of State of California from 2015 to 2021. On January 20th of this year, Padilla was sworn in to the United States Senate by Vice President Kamala Harris, his predecessor, becoming the first Latino to represent California in the US Senate. Let's go ahead and play Senator Padilla's address to this audience.
Hello, I'm Senator Alex Padilla, and I have the honor of representing California in the United States Senate. Thank you for inviting me to open this critical discussion on the fight for voting rights. And thank you to Ms. Riggs and Professor Tolson for your work and your expertise. America's free and fair elections are the bedrock of our democracy. But today, they're under attack. Republican-led state legislatures have proposed or passed more than 400 voter suppression measures in this year alone. Just this week, I met with Democratic legislators who have fled their homes in Texas to prevent a new voter suppression law. As we've seen too many times before, this attack on voting rights is rooted in white supremacy. Civil rights leaders have fought for more than 200 years to expand access to the ballot box. It's our nation's proudest tradition. But since the earliest days of Reconstruction, we've seen how white supremacy rears its head when communities of color make their voices heard in our elections. Today, cynical politicians are spreading false claims of voter fraud for their own political advantage. The country's rejection of a white supremacist president, a president who embraced hate, disdained democracy, and incited a deadly insurrection in our nation's capital, has given rise to a voter suppression drive by Republican state legislatures across the country. It's time for Congress to make clear once again that voter suppression has no place in our democracy. We need to set a strong national standard for voting rights. We need to end partisan gerrymandering. And we need to reform our campaign finance system so that a few large corporations and the wealthiest families in America cannot drown out the voices of millions of voters. The issue of voting rights is personal to me. Before I entered the Senate, I served as California's Secretary of State, the Chief Elections Officer for our nation's most populous and most diverse democracy. In California, we've already implemented many of the reforms in the For the People Act, like automatic voter registration, expanded early voting, and vote by mail. We know that these reforms work. In 2020, California set modern records for voter registration and voter turnout, despite the COVID-19 pandemic. So I'm proud to support the For the People Act and the John Lewis Voting Rights Advancement Act to bring the innovations we used to every voter and prevent discrimination at the ballot box. Protecting our democracy and expanding voting rights enjoys bipartisan support among the American people, but unfortunately, Republicans in the nation's capital and in state houses around the country have shown repeatedly that they value their party more than our democracy. We cannot let Senate Republicans use the filibuster to obstruct Congress while their allies and state legislatures attack the integrity of our elections. We must put every ounce of our being into ensuring that our democracy is as free, as fair, and as accessible to all Americans as we can possibly make it. The legal profession has a critical role to play in stopping voter suppression efforts. And so I call on you, listening to this discussion, to ask what role you can play in the fight for our democracy. We need your talents and training to defend access to the ballot in court. We need your work to make the rule of law a reality for all Americans. As lawyers, you serve as counselors to the courts, working to advance justice. It's critical that each of you stands against the big lie and those who would abuse the law for their own ends. I want to thank you for your partnership in strengthening our democracy, because the stakes are too high to give up the fight. The future of our democracy is on the line.
We are grateful for Senator Padilla's remarks, and we're also grateful to present a conversation about the past, present, and future of voting rights in the US by two veteran voting rights experts. Franita Tolson is Vice Dean for Faculty in Academic Affairs and Professor of Law at the USC Gould School of Law. Professor Tolson is a leading election law scholar, and she has written on a wide variety of topics, including partisan gerrymandering, the Elections Clause, the Voting Rights Act of 1965, and the 14th and 15th Amendments. She is the author of the forthcoming book, In Congress We Trust, Enforcing Voting Rights from the Founding to the Jim Crow Era, which will be published by Cambridge University Press. Some of you may have seen Professor Tolson testify to Congress on Monday regarding the Election Clause and HR 1. Allison Riggs is the co-executive director and chief counsel for voting rights at the Southern Coalition for Social Justice. Riggs' voting rights work has focused on fighting for fair redistricting plans, litigating against voter suppression, and advocating for electoral reforms that would expand access to voting. Earlier this year, Ms. Riggs testified to Congress in a presentation titled Voting in America, Ensuring Free and Fair Access to the Ballot. If time permits, the speakers may answer audience questions. You can submit questions via the Q&A feature at the bottom of the Zoom screen. I may also appear from time to time during the keynote conversation to interject questions in real time. So let's go ahead and welcome Professor Tolson and Allison Riggs, who will begin their conversation by discussing how we got to where we are today.
Well, thank you, Van. Thank you, Professor Tolson, for joining me in this conversation for the American Constitution Society's warm welcome. My history and relationship with the organization has been long and has directed my growth as an attorney and an advocate, so I'm grateful for the organization. As a practitioner, the Voting Rights Act is a central tool that we use across the South in fighting for fair districts, political participation, and an unimpeded right and access to the ballot box. And thinking about where we are today, I find it important to talk about how we got here and how we started our path towards having Congress's assistance in enforcing Voting Rights Act, the full promise of the 14th and the 15th Amendment. And I, in particular, am frequently startled by how little things change. And it's my own privilege to be that startled. But I see today the same arguments used to impede the enforcement of the 14th and 15th Amendment, regulation of the voter rolls, election integrity, and voter fraud being used as justification for voter suppression laws, the same way they were in the rise up to the 1965 Voting Rights Act. Professor Tolson, you're a much more prestigious scholar than I am on the Voting Rights Act and Congress's willingness to stand up. I'm curious what you think too about the parallels between history and today.
So first, let me say thank you very much to ACS for the invitation to be here to have this conversation with you, Allison. I'm so excited. It's not too often that, we have this type of forum where we can talk through these issues. And, I'm just a big fan of the work that you're doing. And this is just a rare opportunity for me. So I think, I think you're exactly right. I'm struck by the fact that, when I teach election law, I teach my students about first generation claims, right? The access issues, just straight up vote denial. And then we move on to vote dilution, right? When electoral structures are structured in a way where it lessens the power of political minorities and racial minorities. But now we're doing vote denial again, right? We're back to first generation claims. And, at first I was like, this is just crazy that we have come full circle again. And it seems to signal that not much has changed, that we have and perhaps it's more reflective of the fact that for the last 3 decades or so, the voting rights community has been on the defensive, right? Just trying to maintain and not lose ground in the face of increasing efforts to restrict the right to vote, as opposed to being on the offensive where we can talk about ways to expand voting access, right? We can talk about a possible right to vote amendment. We can talk about an expansive interpretation of the Voting Rights Act. We've never really been there, right? We've just always kind of been against the wall, just trying to make sure that the right to vote is not completely taken away. And in some ways, it's reflective of the fact that the 14th and 15th Amendments, the full promise has never been realized. So just, kudos to, the senators during Reconstruction who wanted to enfranchise African Americans, but the reality of the situation is that they didn't go far enough. The 14th Amendment never went far enough. And the 15th Amendment sought to supplement that, but it also didn't go far enough because functionally what we need is an affirmative right to vote. And so it's always interesting to me to hear about how voting rights advocates like yourself try to litigate in this framework that doesn't go far enough. You don't have all the tools that you need in order to make sure that everybody in this country who is legally entitled to vote can vote. So, I would love to hear how you sort of tackle those difficulties, because I know the Brnovich decision does not help any. So, just hearing sort of your view of what is on the horizon and how you sort of deal with some of these difficulties would be wonderful.
Yeah, and what's funny too is the 14th and 15th Amendment have never reached their full promise. The Voting Rights Act of 1965 was supposed to help effectuate those, and it's never been enough. I was lucky enough to be practicing when we still had Section 5 of the Voting Rights Act, and it was both an incredibly powerful tool and never enough. The retrogression standard, the non-retrogression standard, wasn't covering enough. It wasn't protecting us against, say, racial gerrymandering last cycle. But even more important, I was really struck in the Brnovich, this sort of transitions us from historical to present. I was so struck by Justice Alito's discussion of what laws and practices were in place in 1982. Section 2 has never been good enough. We got a little, it's never been enough, but it was certainly designed to be flexible and understand next generation vote suppression tactics. I mean, that's the explicit intent of what it was, and a textual interpretation of the statute certainly would get at that. But in Brnovich, we see a focus on, well, out of precinct voting wouldn't have existed in 1982, so Section 2 must not contemplate protecting it.
Exactly.
And that's how we can't escape our we can't escape our own history. But something you said too strikes me as important, and maybe even gets us into the For the People Act, which is, I've found, I work for a community lawyering organization, so I'm a litigator, but we recognize that as much as we believe as lawyers, as advocates of the importance of the protections of the federal courts and the state courts, that historically has just never provided every answer and all the relief needed. And so we work with folks and it's necessary, I find, talking to communities, that it's not just enough to be on the defensive all the time to fight back against voter suppression. We want to be able to articulate what a vision of a truly inclusive and participatory democracy looks like. So we do have lots of tools. They are expansive, and we have incredible clients and partners working on this. We look at novel interpretations. I've brought some really, I think, cutting edge one person, one vote claims where racial and partisan improper considerations were being used to justify population deviations. But I'm really in terms of what are the proactive things that we can do? I know, since you just testified about HR 1, what are the things that you think Congress is most appropriately involved in dictating as far as establishing both a right to vote and creating an inclusive democracy for us all?
So, terrific question, because one thing about HR 1 is that it does touch on different aspects of our election system. So it's about expanding voter registration, but it has things to impose certain ethical reforms. It has campaign finance provisions. It reenfranchises felons for individuals with felony convictions for purposes of voting in federal elections. So it does all of these different things, and in a sense, it's kind of like a best practice. If you look at some of the things that states have done, to the extent that we like to think of states as laboratories of democracy, and which is really a formulation that has been under attack in recent years. But for the most part, most states are doing a pretty good job. It's just we have a number of bad actors. But you can look at states and you can sort of glean from their approaches ways in which we can regulate federal elections that make them more democratic, make them more inclusive, right? So independent commissions to draw congressional districts is something that is in place in a number of states, for example. So HR 1 really does try to capture, at least I like to think of it as the best of us. And so for that reason, it's very important. And it also imposes uniformity where uniformity can be useful. It's not a sense of trying to displace the states as playing a primary role in election regulation. which I think is really important, right? So states still have substantial discretion over election administration, and so on. So, and I think that it also reflects that now is a good time for Congress to intervene, right? I felt like Congress should have intervened a long time ago, right? We're talking about a Voting Rights Act that really needed to be updated in 2006. It needed to be expanded beyond just the South. And so in essence, Congress is trying to intervene now by one, updating the Voting Rights Act, but also with HR 1. But it's also reflective of a fact, if you look historically, what we're seeing is a pattern that's common to our history, right? So states, you have, periods of enfranchisement as we had with Reconstruction, and then you have a backlash, right? So we're having a similar thing here. We had the election of the first Black president in 2008, and then there was a backlash, and then there were efforts to disenfranchise in the states. And then we have a Supreme Court that's hostile to voting rights, as Russ mentioned in his opening statement. So I think in essence, what we have here is HR 1 and then HR 4, which is the John Lewis Voting Rights Act, which is an attempt to respond to some of that. So hopefully, we see some movement. It's an uphill battle, but, just historically, it's really important to have some response to what's going on right now.
Yeah, I was struck. I was honored to argue the Rucho case, the partisan gerrymandering case in 2019 on behalf of the League of Women Voters of North Carolina. And one of the justices asked me, well, why can't we just leave this up to the states to come up with a solution to partisan gerrymandering? And I said, I'm arguing North Carolina right now. Our citizens don't have that option. There is no legislative will for a fix, and a patchwork system of justice isn't a system of justice at all.
Exactly.
And it's true too with the need for for Congress to intervene and update Section 5. I mean, there were cases where I've done cases in Tennessee, which I consider part of the South, but was never states, Ohio, Wisconsin, places where the right to vote has been under relentless attack, certainly for the last 10, 15 years. And state level political changing of tides isn't sufficient when something as fundamental as the right to vote comes up. So I'm curious. I've found I've talked about the need for federal intervention, particularly on partisan gerrymandering. Sometimes folks think it's weird that as my organization is a racial justice organization. We are 501c3. We're nonpartisan, but we believe, particularly as a the strategy and its metastasis across the country, that partisan gerrymandering and racial gerrymandering and vote dilution are quite intertwined. So I'm curious about in your studies how you've talked about that and how it impacts your analysis of the election clause and the need and authority of Congress to intervene on that specific topic.
I definitely see them as intertwined. And in some ways, it's worked against minority rights, right? Just in the sense that the Supreme Court can come in and say, well, this is partisan, and partisan is okay, even though, for example, African Americans vote for the Democratic Party, somewhere north of 90%, right? So the fact that they do that doesn't change the fact that their rights are being impaired. So the overlap between race and partisan affiliation is often used to undermine minority rights in ways that are incredibly problematic. But I do think that, to go back to an earlier point you made, that I think is important and I want to tease out, you talked about how you've come up with creative arguments to address some of these issues. And I think that's really important moving forward, right? As the Supreme Court starts to view voting rights even less favorably than they have in the past. We are also faced with the prospect that, HR 1 and HR 4 might not become law, right? So then it raises questions of, okay, well, what do we do? As you mentioned, you're involved with a grassroots organization. And I think work at the grassroots becomes really, really, really important in this space. because there does have to be a partnership of sorts. There has to be a partnership between those of us who work on the scholarship side, trying to, I often think of, Allison, people like you as like the warriors, right? And so for me, it's like, what arguments can we give the warriors in order to go in court and fight these battles, right? So I think there has to be a partnership there. There also has to be a partnership with the coalitions on the ground who are registering people to vote, who are advocating in legislative spaces for at the state level and at the federal level for new legislation. There has to be more of a focus on election administration, right? So election administration is something that's becoming increasingly partisan, especially post 2020. There was a recent article out about how election administrators are being harassed because of actions taken during the 2020 election, and also how more partisan individuals are starting to run for these positions in order to make our election administration more politicized. And so that's also just another thing to sort of worry about and think about. Not only do we have to worry about issues of gerrymandering, both racial and partisan gerrymandering, not only do we have to worry about issues of dilution, not only do we have to worry about, what's left of Section 2 of the Voting Rights Act, but it's also issues of vote counting, right? How do we deal with issues of, how vote counting itself has become polarized? I mean, you have this effort in Arizona to try to litigate and recount the 2020 election, where you have some company who doesn't even do this work trying to recount the ballots from in Maricopa County from the 2020 election. And so really there's a question of, how do we join together in order to, address all of these issues that's cropping up on all of these different fronts, right? You have to litigate, you have to, come up with new and creative arguments. You have to make sure we advocate in the legislative space. And now we also have to worry about issues of vote counting.
Yeah, that's so true. I was speaking at a Florida ACS event, and I was talking about it. Maybe one of the least sexy elements of what we do. Election administration is so important. We've done a fair amount of work in my organization on administrative disenfranchisement, the way that voters experience implicit bias because of their name or there's a color of their skin, and have interactions with poll workers that tend to either force them to cast a provisional ballot where they shouldn't be, where provisional ballots get counted or not counted because of name, handwriting, you name it. It is critical. And being an election administrator, being involved in election administration, as you point out, didn't get a whole lot more fun last year. We worked so hard to recruit younger, more diverse poll workers. In my home state, North Carolina, going before the COVID pandemic, poll workers were on average 70 years old and predominantly white. And that's part of how the experience of voting becomes traumatic and burdensome, and voters end up disenfranchised. Just like when you have a non-diverse set of teachers in the schools, when you have a non-diverse set of poll workers, it can be the microaggressions and beyond can be too much. So I think one thing we need to do is really stand up for the people that we brought into the process, election administration, support them when folks are talking about their commitment to doing this work, and to doing it in a nonpartisan way of full of integrity, that we need to stand up as advocates for them and encourage the groups that we work with, the community-based organizations, the membership-based organizations, to join in as well. These are the same organizations, Professor, that are inspired by critical legal theories coming out of academia and want more of that, because as much as I might say that there's that going into a courtroom doesn't always provide solutions, there's a fundamental belief amongst the community groups that I work with, Black and brown led organizations, that they're not willing to give up until the courtroom doors are slammed on them. They are not willing to give up demanding the relief that they are entitled to by our justice system. And so they want those legal theories. When I was a young lawyer, an attorney I worked with said, fight for the law the way as you want it to be, not just what it is now. So I'm curious I'm curious about some of your scholarship and of your colleagues' scholarship. What are some of the sort of cutting edge areas and legal tools and strategies you think we as litigators can use?
Oh, awesome. Great question. Because, I sometimes I think of myself as a little too cutting edge.
Not for me. I'm a
Um,
risk taker.
I am team bring Section 2 of the 14th Amendment back. That's how cutting edge I am. And, a lot of my contemporaries and colleagues are like, I don't know about that one. But one of the reasons I focus on Section 2, which is literally the only provision in the 14th Amendment that talks about voting, because it allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote, is because it's a baseline, right? It gives us some sense of what Congress can do in terms of appropriate penalties under Section 5 of the 14th Amendment. And it also informs the scope of Section 1, right? The Supreme Court has interpreted Section 1 to protect the right to vote, but really Section 2 is the provision that talks about voting, right? So for me, Section 2 is sort of my starting point for thinking about what voting means. That's even more important if you think about the fact that the court has narrowed Congress's enforcement authority under Section 5 of the 14th Amendment, right? They've narrowed it, far more than they should if you look at sort of the text and history of Section 2. So I know I'm a bit, off the beaten path, but I am a Section 2 aficionado. And really my work on the elections clause started in a very similar way. I'm like, the elections clause is a pretty comprehensive and broad source of authority, but Congress does not act pursuant to the elections clause a lot. There's not a lot of federal legislation under the elections clause. And so I became really interested in researching the history of that provision. To me, it was obvious why Congress relied on the 14th and 15th Amendments a lot. In the 1960s, it was, a rebirth of those provisions, and the Supreme Court was much more amenable to Congress acting pursuant to those provisions. And eventually, Section 5 of the 14th Amendment became a home for everything, beyond voting rights legislation, beyond any anti-discrimination legislation at all. It just sort of became the go-to provision. And so because there's a backlash now, I became really interested in other ways to defend existing voting rights legislation, but also, expand our view, right? Is there a way to read the Constitution as having an affirmative right to vote, despite the fact that we don't have that language in there? What was the original founding generation? What were they thinking about these issues, right? Because Article 1, Section 2 in particular has always perplexed me, right? So Article 1, Section 2 sets the same qualifications for federal elections as exist for the most numerous branch of the state legislature. So for me, I'm like, well, what if the state fails to call elections for the state legislatures? Does that mean that no one's qualified to vote in federal elections? Well, it can't possibly mean that, right? And so to some extent, the assumption is that somebody would always be able to vote. And so for me, why isn't that driving more of the conversation? For us, the conversation is, okay, who can we disenfranchise? What's as American as apple pie? Disenfranchising people. That's what's as American as apple pie. That has been our story from the beginning, right? And, it's incredible to me that we don't take a more inclusive vision. Even if you look at Section 2 of the 14th Amendment, one of the reasons it gets such a bad rap is because of the provision that exempts for felony or other crime, right? That has been used as broad justification for felon disenfranchisement laws, when in reality, that the Reconstruction era senators and representatives were concerned about disenfranchising Confederates and not Black people, which is what that provision does now, right? So, I mean, it's just, if you think about the Constitution comprehensively, what Congress can do is really incredible. My book in particular talks about Article 1, Section 5, in which Congress judges the elections of its members and historically has refused to seat people who were elected in contests that had significant racial discrimination, right? So even through Article 1, Section 5, you see Congress enforcing the principles of the 14th and 15th Amendment, right? So one of the, what I hope to be one of my major contributions is to force the court to think about congressional power broadly. And not just have this clause-bound interpretation where they can say things like, well, the Voting Rights Act is not justified under the 14th and 15th Amendments, but we can ignore all of this other stuff, right? Because it's not part of how we usually think about these questions. I want to force us to think about this differently. And so that's what my work tries to do in sort of advocating in this space.
Wait till you see some of the claims I'm just formulating as we talk, but I love,
Awesome.
as someone who's worked and worked to combat felony disenfranchisement, the unpopularity and heartburn that we get from the parts of the 14th Amendment that are referenced Section 2, I feel like we need to embrace where we've taken a hit, turning that to our advantage. And one example that's happened really recently in my experience in my lifetime is in the 1990s, when racial gerrymandering first sort of got its name and its teeth as a justiciable claim. It was folks who didn't want to create any districts for Black and Latinx voters to elect members of Congress that were fighting racial gerrymandering, or what they ended up winning in the federal courts as claims of racial gerrymandering. Even though that intentional creation of minority opportunity districts was what led to especially across the South, the first election of candidates of color for the first time since Reconstruction. And in the 2010 cycle, we saw the concerted, coordinated red map strategy to use racial gerrymandering, which conservatives opposed in the 1990s. I mean, racial gerrymandering, intentional consideration of race, recognizing that that demographics are changing, that they could no longer fight the creation of some districts that would elect representatives of choice of voters of color. Let's pack those voters into as few districts as possible. And there was a fair amount of heartburn in progressive civil rights communities about us flipping racial gerrymandering claims against folks, because we had for so long been opposed to claims of racial gerrymandering. We wanted to create race conscious districts that would expand representation for voters of color. But we saw in the 2010 cycle it being used for harm. And it was really undermining Black political strength in North Carolina and Alabama and Virginia. But when we got on board and said, all right, well, we lost in the 90s, but that's the rule of law now. Hey, conservative legislatures, we're gonna bring it back at you. I feel like that was really.
I think that is so important, right? You have to exploit the existing rules, right? If you think about school segregation, that's before Brown. That's all they did. They exploited the equal part of separate but equal, right? Instead of challenging it head on in higher education. At least initially, these cases were litigated on the grounds that the provisions that schools made for students of color were not equal, right? And so that is just a strategy that works well. But I understand the hesitation. It's like, to what extent are you giving sort of a stamp of approval to the existing regime by using the rules? But exploiting the rules is a tried and true tactic that sometimes you have no choice but to do. And I think in the voting space, it's especially important because it's so context driven. Right. So many of the things that we have now, we treat as normal, whereas 100 years ago, they were suppressive. Right. Voter registration 100 years ago was suppressive. Right. We had, individuals who were, recently free from slavery, who didn't know where they lived. Right. Their streets did not have names. Their houses did not have numbers. And so states would say you need to register in order to vote and you need to provide an address. Right. So in that context, voter registration was suppressive. Requiring people to register to vote. Frequently, it can be suppressive. Right now, we take registration for granted, even with the changes that HR 1 are trying to put into place, right? I think that most people expect that they have to register in some form, right? So even if it's same day voter registration, most people expect to register. I think there's only maybe one state that doesn't require you to register. But generally speaking, right, these are things that we treat as normal now, where in reality, it is context dependent, right? And so because we always have to be ready to roll, right? We have to look at these rules in the context in which they're being used. The Arizona laws are a good example of this, right? The rejecting out of precinct ballots, right? The ban on ballot harvesting. In context, these are suppressive measures, right? Native Americans in particular, ballot harvesting is very important for them, right? They may not live anywhere near a post office. They might not live anywhere near election officials where they can cast a ballot, right? So it becomes very important in context. It is suppressive.
Oh, God, sorry.
No, I was going to
It
say,
just-
it requires voting rights advocates to always be able to, land on their feet, right? You have to view the rules in context, and you also have to be prepared to use the existing regime in order to challenge those rules.
It's so amazing that we get pushback on the Supreme Court and Congress saying, well, we want to leave this to the states, but then a resistance to examining the actual context of the suppressive effect of different voting laws. Because ballot collection, particularly on tribal lands where mail service is poor or non-existent, where the socioeconomic disparities are enormous, saying and understanding and appreciating the impact of ballot collection limitations in a state like Arizona doesn't, in the context of the challenges, particularly for indigenous communities in Arizona, doesn't say anything about Virginia, doesn't say anything about California, but there's such a logical inconsistency between being willing to address those issues on the facts. And it's the same thing with voter registration. I get typical talking point, right? When I litigate cases challenging voter ID laws as being suppressive, and it depends on the law, of course, but the expected response is, well, do you believe voter registration is a burden on the right to vote, is discriminatory? And you gave my answer. It used to be, and in fact, I think the failure to modernize voter registration practices is discriminatory and burdensome. It shouldn't be in this day and age with this kind of technology that you can't update your voter registration online. It's not going to solve any and every problem, but we have a whole generation of folks who are experiencing, sometimes I've heard it referred to as millennial homelessness. I mean, we are not the the younger generation being burdened with educational debt, not having some of the opportunities that folks in their 40s and older have had. We need to understand that, moving, couch surfing, staying with people, that makes it really hard to stay registered and be registered. And that might not have been the exact same scenario facing people in earlier generations, but I don't know how to get across to people that we are talking about temporal changes.
And we can't talk about voting as a fundamental right when it's easier to transfer money between banks than it is to change your voter registration, right? Like, everybody likes money. Money is important, right? Nobody would contend that keeping your money safe is not important. Somehow we managed to do that, where you can bank online. But some states make it very, very difficult for people to do the same with respect to updating their voter registration, right? It makes absolutely no sense. But I think you're absolutely right. I think part of it is that there's a failure to appreciate that people have different circumstances that affect their ability to effectively cast a ballot. I think what you've identified is something that we've seen in the context of voter ID as well, because people are just like, well, why can't you get an ID? Well, if a person doesn't have a car and lives 10 miles or more from the nearest ID issuing office, they may not have an ID, right? Like, and there are, hundreds of thousands of people like that. And so in some ways, it's our failure, as a society, to appreciate that some of the less fortunate among us do have these difficulties. And to the extent that we sort of pat ourselves on the back for being a democracy, we have to care about those people.
Yeah. Our lead plaintiff in our voter ID case in North Carolina is a 45-year-old African-American gentleman who has severe cerebral palsy and has had it from birth, and his elderly parents care for him. He doesn't have an ID, or we haven't done enough to support him and his family in getting transportation because he's in a chair. He's very hard to move around. A basic willingness to put oneself in another person's shoes and embrace the uncomfortable reality of the challenges that face people who don't fly for work,
right,
is going to be key to moving forward.
Absolutely.
Unfortunately, we're running out of time. I do want to interject one question from the audience member and put a little spin on it. And Joshua Stein from the audience asks you to help us have hope. What specifically gives you hope at this specific moment in time? And how can you convey hope to us? Both as litigators, what can we do? And what can we tell our friends and family members who are non-lawyers? What can they do, especially in relatively safe states, as Senator Padilla said, like California, that do have so many best practices?
Professor Tolson, after you.
Okay. So I don't have hope. I just have demands. I have a list of demands, right? So to the extent that America prides itself as being a democracy, to the extent that it holds out the promise of voting rights and inclusiveness, I need to be paid. I have demands. Hope doesn't do me much good. Neither does optimism. I operate on anger and coffee. And so, that's the space I live in and doing this work because, I love this country. And because I love this country, I'm going to make this country into what it promises to be. Or I'm gonna die trying and pass it on to the next generation to continue to work. Right. So I don't really work based on hope. I'm more of a, angry type.
Well, and I think of y'all out there in the Bay Area, a wonderful place to be and to live. And I'd encourage you. I find hope or encouragement or energy, however you want to describe it, being in shared spaces like this, listening to Professor Tolson's brilliance and the fact that folks are spending their evening listening to us talk about war stories and cutting edge legal theories. But I encourage you to engage in introspection and self-reflection. We all, regardless of where we live, blue islands, blue states or not, we have a lot of work to do as your president mentioned, in racial healing and understanding of how white supremacy has infected our democracy, including our electoral systems. I am encouraged, particularly as the longer I practice, how community-based organizations, membership-based organizations, especially those with national connections and presence like ACS, the NAACP, League of Women Voters, engagement in those groups helps move the needle and change the narrative. And I think there's a lot of folks doing a lot of good work out there that you can continue to financially support, like ACS, like groups like mine, the Southern Coalition for Social Justice. We can do a lot. We can support our friends fighting and demanding for basic human rights and the promise of what the Constitution offers and should offer to every person and voter in this country.
Well, Professor Tolson, Allison Riggs, thank you so much for such a dynamic and informative conversation. We really, really enjoyed it. At this time, we're coming to the close of our gala. I'm going to cede the floor to my co-chair, Chris Hu, who will deliver closing remarks. Thank you.
Thanks, Van. Hi, everyone. My name is Chris Hu. I'm an associate at Horvitz and Levy, and along with Van, I'm the co-chair of our chapter's gala committee. On behalf of our chapter, I'd like to thank Senator Padilla, Professor Tolson, and Allison Riggs for joining us this evening to share their insights on this critical issue. I also want to thank the team from ACS's national office, Peggy, Megan, Bridget, Emily, and Olu, who put so much work into planning and executing this event. Finally, I want to thank all of you for attending. We hope that next year we'll be able to gather again in person for our annual gala. For those of you who are in the Bay Area and are looking to get more involved in ACS, I wanted to let you know that we'll soon be seeking applicants to join the board of our lawyer chapter. Please keep an eye out for the application, which we plan to make available soon. We're going to close with a short video about ACS. Take care, everyone, and good night.
This has been a tough year, an unprecedented year for everyone.
We are all grieving today. We are grieving the loss of life and the reality that the foundations of our democracy appear shaky at best.
The pandemic.
COVID-19.
The COVID-19 pandemic.
Virtually everything about who has gotten sick and who has not, who has gotten effective treatment and who has not, these all are the products of the society the virus has encountered and the policies that govern our society.
Gun violence, police violence against Black and brown people, violence against Asian American communities.
Insurrection at the Capitol.
The U.S. Code defines insurrection. It was not just a riot, it was an assault on Congress in the middle of the joint session.
We are in a moment of tremendous crisis about whether there would be a handover of power.
And yet, even in a year defined by isolation and distance, people came together in solidarity on our screens and in the streets to join in a historic and ongoing movement for racial justice. As we look to the year ahead, new challenges already await us.
Our mission is to ensure the integrity of our democracy, because it is at its best when every eligible vote can be counted and when every voice can be heard.
The Supreme Court is taking up a case that could overturn Roe v. Wade. More states are passing legislation to deny transgender identity, dignity, and health. And climate change is an increasing threat to our communities. So many of these challenges call for hard truths about our laws and legal systems and whom they really serve.
But we are especially focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equality in this country, and reckoning with our past to create a more just future.
The 13th Amendment abolishes slavery and involuntary servitude, but permits involuntary servitude to the extent that it is a punishment for crime. And we have the immediate attempt during Reconstruction to make Black synonymous with criminal.
Part of the declarations of racism as a public health crisis, some communities are putting in reparations, right? So Asheville, North Carolina, California, Evanston, and Illinois.
It is a time for transformative change.
We are lawyers, students,
Scholars,
advocates,
elected officials,
and voters.
Together, we will advocate for court reform
and insist on a judiciary that reflects the diverse public it serves.
We will work to restore our democratic legitimacy and advance civil rights.
We will mobilize the legal community in support of a truth, racial healing, and transformation commission to ensure a future that is different from our past. Together, we are the American Constitution Society.